Hi all, welcome to the A-Level Law Essay channel. In this episode, the essay is going to be covering the chapter Formation of Contract in the Contract Law syllabus, and more specifically regarding offer, acceptance and revocation. Before we begin, please subscribe to my channel for more video guides on essay writing and many other interesting topics. With that said, let's get started with part 2 essay sample of video tutorial number 11. Question. The question reads, Ian has an antique piano and wishes to get rid of it. He advertised his intention on a local newspaper which stated the starting price for its sale as £20,000 and invited any interested buyers to contact him. Franz saw the advertisement and immediately contacted Ian via email and stated that he is ready to purchase the antique piano. Ian, upon reading the email on the same day, immediately replied Franz and quoted a higher price of £30,000 and said that if he would accept the item for this price instead, he should come to his house to make the payment. Jerry, Ian's next-door neighbor, who saw the advertisement the same day after Franz's email, decided to walk to Ian's house to tell him of his interest to purchase the item. After a long discussion, Ian made a final offer of £30,000 to Jerry, who said that he would think about it and get back to him soon. Upon reading the email the following day, Franz went to Ian's house with a £20,000 check. Ian told Franz that his final offer to him via email was £30,000 and refused to accept the £20,000 check for the sale of his antique piano. Franz then tore the check and decided that he should just give in to Ian's demand for a higher price. Before Franz could write out a new check, Jerry walked into the house and handed Ian a £35,000 check for the item, advised the parties on who has the better contractual right to the antique piano. To answer a scenario-based wrong question, it is important to first identify the relevant parties and the issues that they are having with each other. From the scenario, we know that the disputing parties are Franz and Jerry against Ian. Ian advertised his intention to sell his antique piano on a local newspaper with a starting price for its sale as £20,000 and invited any interested buyers to contact him. Both Franz and Jerry, who were interested in the purchase, got in touch with Ian on different circumstances. Now we are to advise both Franz and Jerry as to their contractual right to the antique piano. After identifying these important things, we should then be able to figure out which chapter in the contract law syllabus this question is covering. By the looks of some of the key points in the scenario, it is safe to say that it covers the chapter Formation of Contract, and that it focuses on the topic offer, acceptance and revocation, as we have to determine who has eventually formed a contract with Ian and thereby having the better contractual right to the sale of the antique piano. Before I begin going through the essay, I would like you to note that my answer is not the perfect essay answer, but it only serves as a guide for you so that you get an idea on how to write your essay and score the highest mark possible for your effort. Incidentally, I may have also left out certain minor details from my content video, as whatever points that have been discussed earlier only serves as a guide for us to reach our end product, which is the essay. One more important thing to note is that since, for examination purposes, the time limit for one essay answer is exactly 30 minutes. I will not have a lot of time to cover every single relevant detail, and the ideal word count for an excellent essay answer is between 700 to 900 words per essay. Introduction. A contract is a legally binding agreement between two or more parties in which mutually agreed obligations are created and can be enforced by law. To determine if either Franz or Jerry has the better contractual right to the antique piano, we first need to consider if a valid contract has been formed as per the common law requirements. Point 1. Body Paragraph 1. The most basic requirement for the formation of a valid contract is that one person must have made an offer and another must have accepted that offer unconditionally. However, an offer should be distinguished from an invitation to treat, and this distinction can only be made after examining what actually transpired in the deal. Based on the facts, Ian made his intention known via an advertisement, and it is clearly an invitation to treat, since he only stated a starting price and did not offer the antique piano for £20,000. The case of Gibson versus Manchester City Council, 1979, shows that there is no offer to be accepted when one person merely makes an invitation to trade. This would mean that Ian merely invited an interested person to offer him the suggested price for the item that he intends to sell, and anyone who approaches him with the suggested price is the one making the offer to him. Point 1. Body paragraph 2. A clearer situation can be seen when we contrast the two cases of Carlyle versus Carbolic Smoke Balls, 1893, and Patridge versus Crittenden, 1968. The former case illustrates that if a unilateral offer is made by way of an advertisement, then anyone is entitled to accept it by making the relevant performance of acceptance, thereby creating a valid contract between the offerer and the offeree. The latter case shows that if an intention to trade is made by way of a bilateral advertisement, i.e., that a list of goods with stated price is circulated, then it is not treated as an offer to the world, but merely an invitation to trade with the owner of the goods. Therefore, applying Patridge's case into the scenario, the offer should be made by anyone who is interested to buy the antique piano from Ian and not the other way around. Point 2. Body paragraph 3. Treating the initial advertisement as an invitation to trade, we will now consider if there was a contract formed with either Franz or Jerry. Since Ian did not accept Franz's offer of £20,000, there is no valid contract of sale as the offer was not accepted unconditionally as per Tin versus Hoffman, 1973. What happens next is Ian countering Franz's offer by raising the price to £30,000. Following the case of Hyde versus Wrench, 1840, Ian's counter-offer will supersede Franz's offer, thereby terminating it. Since, on the facts, Franz did not accept the actual offer made by Ian immediately, a contract for sale is still not formed. Instead, what happens now is that Franz is given a reasonable amount of time to accept it before the offer is terminated or lapses. Point 3. Body paragraph 4. The case of Payne versus Cave, 1789, establishes that an offer can be terminated any time before the offeree accepts the offer. With that in mind, we will now have to discuss the contention between Franz and Jerry to determine who has the better contractual right to the antique piano. Based on the facts of the case, after a long discussion, Ian's final offer to Jerry was £35,000 for the item in which Jerry, again, did not immediately accept, but told Ian that he would think about it and get back to him soon. At this moment, since no one has accepted the different offers made by Ian, no contract has yet been formed, and as mentioned earlier, an offer cannot last forever, as it will only be there for a reasonable amount of time until it is either terminated or lapses. Point 3. Body paragraph 5. As much as offers made by the offerer can be terminated any time before acceptance by the offeree, it must also satisfy the requirements of communication. This would mean that for the offerer's withdrawal to be valid, his intention must be effectively communicated to the offeree before he accepts the offer. The case of Bryan and Co. versus Leon van Tienhoven, 1880, shows that so long as the offeree is informed and aware of the termination, there is valid communication of revocation. Additionally, Dickinson versus Dodds, 1876, shows that revocation of an offer can also be made through some other reliable source, i.e., a third-party communicator. As the fact shows, Jerry's acceptance of Ian's final offer of £35,000 was presumably done in Franz's presence, and so a valid communication of revocation is direct and obvious, as he would definitely know that the antique piano has been sold to someone else. This is especially so when the conclusion of the contract was done before Franz could even write out a new check for Ian. Conclusion. Upon discussing all that has transpired, the contract for sale of the antique piano is concluded between Ian and Jerry, and so Jerry has the better contractual right to the item than France, whose act of accepting the offer came too late. That is the end of the essay sample for this video tutorial. If you have any questions or opinions on my approach to answering the question, please do comment below. Do check out part 1 of this video tutorial for a proper content guide on how to answer this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more. Thank you for watching, and I'll see you again next time.